Okay. So first of all, thanks to everyone for being here on this Friday morning. Um, we appreciate your time and that you are hoping to learn more about how to help engage youth in court. We have a guest speaker, Lauren Bodan, here this morning. So I have a few quick just housekeeping things, and I'll introduce her, and then we'll get going. So, just a reminder, in services, we put out weekly reading every week. And it's not just reading, it's also things like this and different in services and things in the community. So please check that out. We also have a volunteer section on our website where there's more resources and some of the slides from prior in services. You can also read books and podcasts and watch movies to get those 12 hours per year. And you can cater it to what you need for your cases. And the other thing is, while we're on Zoom, if you could make sure you mute yourself unless you're speaking, that just helps avoid distractions and keep things running smoothly. We'll have some time for questions at the end, and if there are questions that we don't have time to answer, please reach out to me or the supervisors, and we'll try to make sure everybody understands everything. So that's housekeeping. We invited you all here today. This is kind of a little extra push for more folks to be at this in-service because everybody will be kind of helping with this process. We really think you should be offered a chance to participate in the hearings. They're making decisions about their lives, and so we want them to be involved in that in the way that's appropriate for them. For some of them, it needs to be more therapeutic, might need to be at a different level for their age. But I think the best practices court team worked really hard to create these protocols that we're going to learn about today to support the youth as they engage in the process. And you will also learn about the pieces that we are going to be helping with as CASA. Some maybe you're already doing, and some are new. Um, so we have Lauren Bodan here to give us kind of the spiel and the process and the reasoning behind all of this. And she's a senior assistant county attorney for Albemarle County. She joined the county attorney's office in 2022, and her first client for the county was Albemarle County Department of Social Services. She represented Child Protective Services Unit and Foster Care Prevention and Family Preservation Services Unit. And she's also provided legal advice to the department on day-to-day operational issues. She now supports the public safety portfolio in the county. And prior to her work with Albemarle County, she was in private practice as a civil defense attorney in both Virginia and North Carolina. So she has a wealth of experience, and you've probably seen her around and seen her in court if you're here in town. And we're just glad to have her today to share this information with us. So thank you, Lauren, and I will turn over the floor to you.
Thanks, Leah. I'm happy to be here with everybody. Thank you all for joining us. I recognize some familiar faces on screen from court. I definitely see Nick. Nick, my former paralegal, was lurking in that group of faces somewhere. And so it's nice to see everybody. Some of you may recognize me from court. I am the attorney for DSS, or at least I was for several years, but I haven't been in court as much anymore. But I am on the best practices committee for Albemarle County. And I'm going to give you a training today that we also gave at the best practices committee's conference this past fall. For those of you who don't know, the Best Practices Committee is a group for the Charlottesville Albemarle Juvenile and Domestic Relations Court. JDRs throughout the state have this group, but it is a group that essentially tries to make sure that our courts are following the best practices in child welfare cases to the best of our ability. And on that team is, of course, the judge, who's the head of the team, and the clerk's office, attorneys that represent the department, GALs, parents council. Kate Duval from CASA is on that team for us. The court services unit for the 16 Judicial District is on that group as well. So basically the idea is to kind of get all the different perspectives around the table and try to make sure we are doing the best we can for kids in these cases that, as you all know, are extremely challenging and difficult under the best of times when we have things working right together. And so one of the things that we kind of identified as a group is that The science, the research, and the prevailing winds are telling us that kids need to be more involved in court, and that was a place where we had not traditionally had kids super involved in coming to court for their cases, and that is a place that basically, the new information is telling us we should be taking a different approach, and so we've been trying to work to create a new approach. Judge Pather saw a presentation from Roanoke JDR about their protocol that they used in court, and that kind of inspired this whole thing that you're going to hear about today. So, with that kind of background on the committee and how we decided to engage in this process, I'm going to take you through some of the things we learned and ultimately the protocol that we implemented at the end. And so. Certainly feel free to ask questions. We might try to use the chat or the hands up. And maybe Leah, if people have questions, you could help me triage that as we go. But this presentation was originally given, some CASAs were there, but mostly for lawyers, so it is a little dense. So I apologize. I don't have anything spiffier than the outline on the screen, but let's get started. So the need to engage kids in court is rooted in both statute and legal best practices. The intent of this CLE was to demonstrate the need and the benefits to engaging youth in child welfare proceedings. We're going to cover first the reasons children should be included, second, the legal requirements to include youth in court, and propose a new protocol to engage youth in court. And finally, in the materials is some additional resources to help you engage youth in court. So we can definitely send those over afterwards if people want to look at them. But basically, just like some questions like, how do you talk to kids about this? Here's a questionnaire of things you can ask them before court. Here's some things you should tell them about court. Just some like kind of cheat sheets and materials that folks in other jurisdictions have made, just to give you some ideas on what do you say? How do you answer their questions? What questions should you be talking about with them? So, anyway, that's kind of where we are, but those resources are available to you if you'd like me to send them over. So first of all, the need to engage youth in the court process in child welfare cases. So there are two major kind of legal bodies that have told us why this is important. The first was the American Bar Association. In 2022, they passed Resolution 613, and there was a report attached to it. I'll send you all the full report as an appendix to these materials, but Resolution 613 urged courts and children's attorneys to support a presumption of child presence in dependency proceedings by changing rules and policies to accommodate children, as well as by providing training to judges and practitioners. The report that went with the resolution was really persuasive for me personally anyway. It highlighted how the presence of children in court improves outcomes. The good thing about the ABA is sometimes they can help fund research like this, and also they have full-time staff attorneys who, unlike me, have time to read some of these reports and research that our social scientists of the world are doing. But a research project from New Jersey that was cited in the report revealed that 97% of child participants varying in age from 4 to 18. So that's a huge gap in the kids there, right? That's like all of the ages basically. We're glad they came to court and would want to come again, and 81% said it felt like a good experience. Researchers found that participation enhanced children's trust in the process because they felt the judges knew enough about them to make the right decisions. There was an evaluation or a study that was done in Colorado, and that demonstrated similar results. When asked if they felt adults in court listened to them, 94% of the children who attended court said always or sometimes in response to that question. By comparison, children who did not attend the hearings were not convinced the judge had adequate information to make a decision in their case. So for kids, that face-to-face interaction is invaluable in gaining their trust and buy-in in the court system, that the judge knows them. And look, sometimes the judges have to make the decisions in these cases that the parents were not making, right? The hard decisions, the tough decisions, the I'm going to be your parent, not your friend decisions. But I think if kids believe in the judge and they believe the judge knows them, they may even have buy-in on those types of decisions too, based on what these findings were telling us. Um, Another important thing this report highlighted was that although there's a presumption of presence in many courts, like there is in the Commonwealth of Virginia, child attendance falls short, and how courts can change or implement new policies can help better facilitate that presumption becoming reality. Um, the core principle the resolution is trying to assert is that rather than children having to assert their right to attend, there should be a presumption that the children will be present unless they choose otherwise in consultation with their GAL. And presence, they highlighted, which I think is important, as an important thing that a role that CASA plays, and also then holding our GALs to this role. Presence doesn't just mean attendance, it means adequate preparation with the child by their attorney so they can meaningfully engage in court. And I think that's where GALs and you, CASAs, will get a lot of questions about, like, what should I expect in my case? What is the judge going to ask me? What does the room look like? Who's going to be there? Why is my aunt allowed to be there? Why is my uncle allowed to be there? Is my dad going to be there? Right? Those are the things that you have to kind of prep them for so that they're not taken back and scared and don't want to talk at all or share their feelings and that sort of thing. Obviously, that is primarily, ethically the GAL's role, but I feel like CASA's, because of your relationship with the children, probably are going to end up getting a fair amount of questions in that vein as well, potentially. So certainly it's something we want you all to be prepared for. And it's something similarly we've talked with the social workers about, because I do think they'll probably end up fielding a chunk of those type of questions as well. And then the other major kind of body that we look to is the National Council of Juvenile and Family Court Judges. And they had a children in court policy statement that they passed as well. They took a broader stance, stating that it should be the policy that children of all ages attend all hearings until a judge determines it's unsafe or inappropriate. That the key requirements from their policy statement was, first, that judges must receive training on engaging children. I think we're in good shape in our courts, and that Judge Griffith and Judge Pather seem really into this and have taken trainings about this, and also just generally have had a career in practice where maybe they're more prepared for that than somebody who, for example, came off the general district court bench and only dealt with adult criminal cases, something like that. But that certainly is important. And I think that that's a place where, like, if you feel like a judge is falling short, you should talk with your CASA leadership, because they do have a seat on that best practice committee. And we can say, hey, I think the judge needs additional training on, trauma-informed language or something. And that's definitely something we could try to get, even for attorneys, would be helpful too. So that, like, stuff like that. If you're seeing gaps and you think there's additional training opportunities, like, we're all at the table, right? We're all partners at the table. So you should kind of talk about that with folks if you're seeing things. But secondly, that courts must develop policies ensuring attendance opportunities. And that's what we're trying to do here, is start with this protocol, because we don't have one currently. So we're starting from zero. Children should be legal parties with competent representation. Obviously, the kind of baseline law in Virginia covers that, and that kids have to have a GAL for court. When children are absent, judges must inquire why and continue cases if no good cause exists. So that's an interesting and kind of broader than the ABA's statement. I don't know that we're there yet, but it is interesting to see, the ABA took it here, and then this next group takes it just even a little bit further. And courts must work with agencies to ensure transportation. I know for a fact from our social workers that transportation is the barrier sometimes, right? We know when kids are placed 3 hours away, that means they're going to miss a full day of school. Getting there is really hard. The foster parents may not be able to drop everything in the middle of the day to take this kid to a hearing and then sit there for 5 hours when court gets backed up. And so that's some of the things that we've talked about and concerns that we've identified. We've tried to address them in the protocol, which I'll talk with you all about in a little bit. But we're hopeful that our protocol at least gives a starting point for some of those problems. And then it provided, when we were in at the CLE, Morgan Cox provided some personal but anonymized examples of when including children in the court proceedings improved outcomes. I'm sure those of you who have been CASAs for a while probably can think of some cases too where having your kiddos come to court did help improve things in your cases. And I think we probably all can think of cases where it just really isn't appropriate for kids to be there. And I do want to assure you that like our protocol does address those types of things, but certainly I think there were a lot of good stories shared by some of the GALs about times where it increased buy-in or they got to better outcomes because of kids being able to be present. Um, so next, I'm going to talk about some of the legal authority, the statutory authority and requirement to engage youth in court. First of all, is the notice of petitions. This is all petitions, including the petitions that accompany foster care plans, but they're governed by Virginia Code 16.1-263, and it requires that courts shall direct the issuance of summonses, one directed to the juvenile if the juvenile is 12 or more years of age, which I'm sure some of you probably already know from your cases, but if your kiddo is turning 12 or just turned 12, they are going to start getting these petitions and plans. And so that's something we want to make sure the GALs obviously know it, but we want to make sure the CASAs and the social workers are aware. Like if your kiddo's 12th birthday is coming up, it's time to start talking to them about, hey, you're going to get this plan, and in it is probably going to be mom and dad's drug results. You know what I mean? And so you got to start thinking about that and think about, maybe you want to read it with your foster parent there. Maybe you want me to wait and read it when I'm here with you, as your CASA, or you want to read it with your GAL or whatever. But those come in the mail and they come from the clerk. And obviously the clerk has no control once it's in the mail of when it's going to arrive and how it's going to get there. And so if you think that I think CASAs are really invaluable to us in this way, but working with the social worker or the GAL, whoever's the, kind of more present or more party you're more plugged in with on your team about like, okay, we've got a kid who's going to start getting the plans for the first time. What's our process going to be? How do they want to read them? How do we, if we think it's going to be upsetting, are they reading them in a safe space? Like, are we talking to the foster parents to make sure they've got therapy set up right afterwards or whatever that's going to be? So just be aware of that from 12 on. That's going to be the case. Obviously, some kids come in older than 12, so that's the only interaction they know with the system is having everything from the start. And for the bigger kids, I think they want to read what's in those plans, So I think that's a good thing and it's a good legal requirement. But in addition to that legal requirement to at least share the petitions and the plans that are going to be attached to them, the judge can also endorse on the summons an order directing the parents, guardians, or other custodians having custody or control, so the foster parents, to bring the juvenile to the hearing. And I think that this is the case sometimes where we get frantic calls from foster parents like, do they have to be in court? Are they in trouble? Blah, 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 that sort of thing. And I mean, the answer is if the judge says that she wants that child there, then yes, they do have to be in court. That's a court order. And so I think that we will probably see potentially our judges using this a little bit more as we start to engage this protocol a little further to make it clear that they expect the children to be in court. There's also some legal requirements for foster care plans. 16.1-281 is the controlling statute, but that requires the local Department of Social Services to file foster care plans where kids are in custody, and it requires engagement of the children in foster care process in the following ways. So as the social worker is working on that plan, the caseworker has to involve a child who is 12 years of age or older in developing that plan, and at the option of such child, up to 2 members of the case planning team who are chosen by the child who are not a foster parent of or caseworker for the child. And so I'm sure some of you who have gone to FPMs have seen this. Some of the older kids will be like, I want my teacher there, or like my coach there, or I want my friend's mom who I'm living with there, that sort of thing. And so, but this is a legal requirement in the code that kids get to pick their support person. So, unfortunately, I think in some of these cases, these kids don't even have 2 people they can pick to be on these teams, unfortunately. But I will say I have seen in cases where that has changed for the positive over time as a kid's been in care. All of a sudden, they have some support and resources. They have a teacher at the school who they become close with, or they join a club or a group and have a friend that they want to involve. And so I have seen that change for the positive over time. And I mean, I'm sure you all are potentially aware of this, but there's research and evidence to suggest that as long as kids have one kind of stable adult, that they can kind of make it through a lot of pretty bad scenarios. And so maybe, that's a place for CASAs too, to kind of help say to kids, like, who's your trusted adult? Who do you go to at school when you have a problem? Maybe, if it's, my sister was tardy all the time when she was in high school. She could never get to school on time. She's a perpetually late person, but she became very good friends with the front desk lady at our high school who checked people in for attendance because she was late so much. Like, I mean, it could be as simple as identifying, hey, who have you become friendly with at school? For my sister, that trusted adult was probably the attendance lady because she was trying to scheme her to not get another detention for being late. But kids have these support people. They may just need some help kind of pointing them out and finding out who they are, especially our kids who have been through a lot, who are not so trusting of adults in the world. So, but that requirement is important, and that I do think is a place where CASAs can sometimes maybe help fill the gap sometimes as you get to know kids and talk to kids about who should be your two grown-ups on this support team, or not even grown-ups, two people on this support team for you. It could be, an older adult sibling or something like that who can't have custody but could be there for them in this way. So that's an important thing. And I feel like sometimes the social workers too are in a place where they have a lot of cases and they may not have as much time to kind of do the digging to find those additional adults. And maybe that's a place that CASA could help us close the gap. But children under 12 may be involved in the development of the plan if it's consistent with the best interests of the child. And I think we all know that there probably are a lot of kids under 12 who should totally be involved in the development of their plans and are going to crush it in that role, and some that just aren't mentally or intellectually maybe there to help with that. And so that's kind of a case by case basis. But definitely work with the social workers, and also feel free to push back on the social workers if you think you've got an under 12 who really wants to be involved in this. If the parent or child is not included in the development of the plan, the department must include in the plan an explanation of the reasons they have not been involved in the development. And so I have kind of pushed on the social workers. I will tell you that if you've got a kiddo with an intellectual disability or something like that, where we know they're really probably never going to be that involved in the development of their own plans, that stuff needs to be documented for the judges early and often, that we need to be looping the judges and the court in fully on that child's special needs, on the IEPs, what they need basically to be successful as they can be, and doing a better job documenting that. And so hopefully we'll see some improvement in that area. And I think it's also important because it provides education for the judges about some of these bigger picture issues that face kids with special needs who unfortunately make up a large percentage of our foster care population. Um, for kids 14 and older, they have to sign an acknowledgement that they've received a copy of the plan and that it's been explained to them in an age appropriate manner. And this is a place where I've identified for the social workers and the GAL, it's like, this is a place where you guys have to work together well, because the social worker is going to explain to this kid what's in the plan and they're going to sign it. But the social worker is not a lawyer, probably has been to court a fair amount, yes, but can't really answer legal questions. And so that's a place where we've kind of pushed on our protocol. Like, social worker needs to be taking one piece of this puzzle, which is like, what services are you putting in place for my parents so that I can feel safe going home? And the GAL needs to take the other piece of this puzzle, which is like, when they ask a question about the timeline or how long do they have to fix it or blah, blah, blah. Like, look, some really good social workers who've been at this for a long time probably could answer those questions fairly accurately, but those are truly legal questions, and the GAL should be filling that gap on those questions. Um, and so anyway, you'll see in the protocol, but we've tried to address some of this, where there's going to be some overlap or some different people needing to play their roles to give the child a complete picture on some of these things. The code also requires the court send a copy of the entire foster care plan to every child who is 12 years of age or older. So we already talked about that a little bit, but that is a legal requirement in this section of the code as well. For subsequent foster care hearings, the they have to provide a copy of the plans, notice of the hearing, and it's both implied and explicitly repeated throughout the statutes for all these subsequent hearings, requiring the court to provide that notice, a copy of the plan, and part of what they're providing is that each party who receives a notice from the court is entitled to participate in that hearing. Um, that's true at foster care review. That's true at permanency planning. Um, for permanent foster care, which we don't use all that much in our jurisdiction, but for permanent foster care, for those that you may have seen it, but probably more of you probably have not seen it, there is a requirement that the court consult with the child to ask the child about their desired permanency outcome, make a judicial determination, and accompany it with an explanation of the reasons that the alternatives are not in the best interest of the child. So basically, I mean, that's why we don't use permanent foster care that much because it is disfavored under the law. You have to be able to say why these other things are not better for this child. As you all know, the goal is always permanency, and permanent foster care is not seen as the highest ranking of the permanency options. The best practice, of course, is to pursue either adoption or relative placement if you can. Um, if the child is transitioning from foster care to independent living, the court also must consult with the child regarding independent living. Again, we don't use independent living a ton in our jurisdiction, which I think is a good thing and compliant with the law. But certainly, I think we all know we've had older kids that want to do that independent living, and they should be prepared to answer those questions first from the social worker, who's then going to pick that as their plan and put it in the plan, but also from the judge, who's going to say, why should I do this instead of, why should I basically send you out on your own as a teenager versus a plan that puts you in a family, right? And there may be very, very good reasons our kids have for that, and that's totally fine, but they should expect that they would have to speak with the judge, the GAL. They're going to have to talk to a lot of adults about that, right? And so they should be prepared for that. The annual foster care review requires the same things once parental rights have been terminated. And then, of course, I suspect some of you know this, but the court cannot terminate parental rights if a child is 14 or older and objects to termination. One of the things that ended up being very interesting about this for me, having only practiced in two places, Miss Cox was, who has gone to more of these national conferences, was able to point out that apparently Virginia is one of only like a couple states that has this requirement that over 14s can object to TPR. And so that's an important thing to kind of keep in mind too, as we talk about some of those alternative options like permanent foster care or independent living, is if you've got a 14-year-old who says, yeah, I don't want to go home, but they're still my parents, then we got to find a plan that works for that. And then, of course, there is kind of a carve out to that in the law that a child 14 or older may be terminated over the objection of the child if the court finds the disability of the child reduces the child's developmental age and then the child is not otherwise of an age at an age of discretion. And so that was also consistent with what I was talking about before, is if you have a kiddo who's not going to be able to come to court, can't handle court, intellectually just isn't in a place for court, we need to be documenting that early and often in the foster care plans on our side, but I also think on the CASA report side, anything you do to help, because you spend so much time with the children on your cases. I think some of the things that can be helpful for the judge is like I remember we had one kid who was like obsessed with unicorns and rainbows. She's older and probably is past the age of those things, but that was like a thing that we used to help kind of contextualize, like her interests are still like mermaids, like really mermaids, like, and unicorns and like that sort of thing. So that's some of the things I feel like your reports always give a little bit more color and humanization than the bureaucratic outline of the foster care plans allows for. And that might be a place too where CASAs could really shine and provide the good information that you all always do to the court. But maybe sometimes for our kids with additional needs or special situations, helping provide some of the context to the judge is like, this is what we talk about, or these are some of the questions that they're asking, or, I've talked with the teacher and this is the level of functioning we're dealing with, stuff like that, that can help put it in maybe some more real world stuff for judges. I feel like it's really, really helpful. And that's a place that CASAs do a great job, again, of helping, I think, fill that gap in some of your reports. Because again, they're a little more colorful and a little less dry than the stuff that we're legally required to file. Um, and Morgan added this point, but I think it's really helpful. It would be difficult for the court to ascertain the child's feelings about termination or make the determination that they're not at an age of discretion without having consulted with the child at the hearing or in previous hearings. And that's true, right? If the first time you're coming in with this kid and they've never been to court before and the judge has never talked to them or talked about them or really knows very much about them, and they're coming in and they're saying, I object to this, like, well, why? Or um, on the other side, maybe mom and dad are working really hard and they're saying, I don't care, I don't want to go back. Well, why? If you don't have the track record with that child and seen them kind of progress over time throughout that, 12-month timeline that we're on, I think that's hard for the judge. And so I think that's a really fair point that the committee kind of has made and come up with. So high level stuff. In summary, children 12 and up are required to and will receive a copy of the filings from the petition onward. Children 12 and up will get notice and are legally entitled to attend every hearing from the filing of the petition onwards. The court is required to make a finding that they've consulted with the child or why consultation is not practicable or in the best interest of the child. And then accordingly, the best practices committee protocol, if followed, will ensure all legal requirements will be met in child dependency cases. So, that was a lot of boring stuff, but now we're going to get to the fun stuff. The Best Practices Committee, pursuant to those recommendations from those two major national groups, the Virginia Supreme Court's Court Improvement Program and our own committee created this protocol and checklist for engaging youth in court during child welfare cases. The reason we did a protocol and a checklist was because it's kind of the same reason you have policies and you have procedures in an organization. Your policy is like your best, this is how it should do. And our hope is the checklist is the policies to hold people a little bit more to the fire to say, hey, did I check my box today? Like, I know that I am one of the two people that's supposed to be working on this thing. Can I check that off and say that I've done that? The protocol that we created focuses on ages 12 to 17. That's to meet the statutory requirements and also to inform suggestions for later expanding the protocol to include younger children as well. And so, like I said, we don't have a protocol in place currently, and we are not doing this right now. So we are starting from zero. And so we went through several versions of this protocol that was an attempt to do like 0 to 18. And we had all these different levels for all these different age groups. And we were trying to break kids up into the right age groups and brackets. And these types should do this age should do this, blah, blah, blah. And ultimately, we didn't really feel, once we got through everything, we were writing and rewriting and changing. And we actually scrapped that version and said, you know what, we need to back up. We need to start way simpler than this. The law requires 12 and up. Let's start there. And so, like I said, we kind of scrapped that Roanoke protocol that was like all ages because they'd been doing this for longer. So they had more recommendations for all ages. And we kind of backed up and said, okay, let's start on 12 to 17. And our hope is not that we're using these kids as guinea pigs, but 12 to 17s have a legal right to be there anyway, and so they can all come. And so our hope is that we will learn more about how to do this well with our bigger kids who are more independent, autonomous, and have more of a voice, and that we can use some of those ideas to inform making better suggestions for our littles who don't have that level of insight, autonomy, and independence. And so that's kind of why we decided to back off, up the age of the protocol, and kind of start with the bigs and we'll work our way down to the smalls after we learn some stuff here. Because again, we are kind of starting from the beginning. The focus of the protocol is to require presence for children aged 12 to 17 that will want to attend and meet the criteria, but also emphasizing participation for all children, regardless of age or desire to attend court. Like I said, we do have some additional resources for ideas on participation for younger children or children who do not want to attend court. Even though those younger kids will not be in the protocol, I do think you all should feel confident in using some of those additional resources or other ideas we've suggested for kids younger than 12 too. Like, I think that's totally appropriate, and we'd like to see the ball start rolling on some of that stuff again, so we can get some ideas about what is the right thing to do for the 0 to 12s. The protocol, I do want to focus on this a little bit, the difference between presence and participation. So this is something we talked about a lot. Presence, of course, is like presence in court, standing there in front of the judge, asking the questions that they want to ask and getting asked questions by the judge or the attorneys or their social worker or whatever in court, physically there. Participation we view as a little bit bigger than that. So some kids may say, I think we've all had plenty of cases where they say, I am not going back in that room if my dad's in there, right? Like, I am scared of him. I'm afraid of him. I do not like him. I'm not going if he's going. Okay. Totally reasonable under our protocol that we've proposed that you might not want to do that. But then how do we get you to participate in court so that you still have a voice, so that you still know the judge and the judge knows you? So how are we going to work that out to be the right fit for you? And it might be on some of these cases saying kiddo is going to come in for 5 minutes at the beginning and talk to the judge, then she's going to leave, then we bring the rest of the parties in, right? Maybe. Or maybe it's something else, such as some of the additional ideas we've proposed, which is like writing the judge a letter, filling out a questionnaire with them to give to the judge about some things that they like, what they're working on at school, what clubs they've joined, what their grades are, what they want to do next semester. Are they in the marching band? Stuff like that. And so we want to emphasize that participation. And I do think that that's another place on the participation that CASAs can really shine because, like I said, we're not sure what that full scope of participation, presence is obvious, right? Standing in court. What participation could be, that could be creative and it could be different for each kid, right? Some kid might say, I want to make a TikTok for the judge. Okay, great. Like, let's do it. Like, we're open to new ideas. So if you and your kiddo have an interesting idea of how to increase participation, like, I think there is appetite from the best practices committee to try it, right? So if you've got a kid who's like, I love art and I just want to show the judge the picture I'm working on, great. Like, that's fine. That's good. Like, let's think outside the box about how we can connect with people and meet these kids where they're at, right? And so I just want to talk about that difference between presence and participation a little bit. And then I am going to show you all the protocol and the checklist. But like I said, the protocol is like, here's our best practice sort of deal. The checklist is a little bit more to kind of hold people to, okay, who do we, the committee, see as the actual individual human who is responsible for this in our system? And that way, this checklist will help people understand, okay, this one's on the social worker, or this is, like I said, with the plan, like that has to be a social worker conversation and a GAL conversation because we're talking about services, but we're also talking about legal requirements in that plan. And two people probably need to deal with that to fully answer the scope of the questions kids might have. Another good example we got was like when there's a court order after the case, the social worker may give the kiddo a copy of that order. They're going to get a copy of the judge's order. And then they might say, well, Miss Phillips, I'm picking on Pam Phillips, but she's the first person that brought to my brain. Miss Phillips, what does this order mean? And Pam can say, like, she's been a social worker for a long time. She can say, like, well, the judge is saying you're going to stay with your foster parents for a little while longer. And, we'll be back on the date at the bottom, right? But kid may have more specific questions than that. And then at that point, it's Pam's job to redirect kid to GAL to say, hey, she's got some specific questions about what these provisions mean for how her dad can contact her, right? And so that's a question that the GAL should really be helping a kid pick apart. Social workers are always going to do their best. Our social workers are very good about coming back and calling the county attorney's office if they're not sure what a provision in an order means. And I am thankful for them every day that they trust our counsel and will turn around and call us. But that's definitely not a position I want to put them in to be the person explaining that to a kid with no legal education, right? So the checklist was our way to kind of help sort out and provide clarity for all of the participants on a child's team as to who is responsible for which task. And so I'm gonna, like I said, we have a ton of additional resources here. I can send all of these out. I think Leah might have them from the conference, but I can send them all out as well if you all are interested in that. But that's kind of what we covered. And then I am going to show you the protocol itself. For the protocol and the checklist. So I
And
am going to
Glenn,
make these bigger. Yes.
I have a quick question. So in the chat,
Yes.
Liz was asking if kids are really intimidated by the courtroom itself. She asked
Yeah.
if they could meet the judge outside the courtroom. And I know we talked a little bit about, they can go in those side rooms, but I
Yeah.
don't know beyond that.
Yeah, that's a great question, Liz. So I mean, obviously they can't like meet the judge in the street because we wouldn't have adequate security or safety. And I don't think that I think the sheriff's office would have a meltdown. But we are looking for ways to make things less formal. One of the things Judge Pather has talked about a lot is that she is willing to come off the bench to just sit at a table with the kiddo or just sit in the benches. So that's something we're definitely open to and looking to get also like feedback from you all about like, hey, that went way better when Judge came down or when Judge didn't have robes on or whatever. And that's something Judge Barry did many, many years ago, which again, maybe wouldn't get by security protocols today, but he just used to meet with the kids in the side room around a table. And so that I think stuff like that can feel a lot better for kids. We want to have some amount of formality that they understand that the judge's decisions are binding and important and they're taking it seriously, but we don't want it to be so formal that they feel like they are a cog in a machine, that they don't have a voice and a connection with the person making decisions for them. But that is definitely the type of thing we are looking for feedback on and also the right way to do it. So if you've got a kid that's telling you that, Liz, like, let's get with the GAL, let's get with the social worker, let's get with the DSS lawyer about making that request to the judge. And in my conversations with Judge Pather on this best practices committee, I cannot imagine she would say no to some reasonable solution that is in the middle there. We've got this new kid-friendly child waiting room that we've been working on one of the side rooms. That could be a good potential place that's just like a little, less government building. Yeah, our hope is that that room is gonna, and look, I work in a government building. Okay, I'm not trying to be critical, but like a little more of a space where you're like, ah, yes, children might come in here and have joy, as opposed to like the blank slate of the courtroom, the hospital white of the walls sort of deal. So yeah, that's a really good question. Good question, Liz. Thank you.
Diane had her hand raised. I don't know how you
I
want
was just going I was just going to add that I had a case last month, a 12-year-old in court with Judge Pather, and indeed what she did was the child sat in that Judge Barry special room, and Pather left the court and sat with her about 25 minutes to discuss things. And then the child asked to see the court. So Judge Pather gave her a tour of the court, including her judge's chambers. And then the child left and went back to school. And then Judge Pather reported to us what the discussion was. And that worked out really well.
Yeah, that sounds awesome, Diane. Thank you for sharing that. And that's definitely the type of thing we're looking to do better, to be better on. So any input you all can give us as CASAs is like invaluable. So we really appreciate that. I always, 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 if I have a kid who's going to testify, I take them to the courtroom before the trial. I have them sit in the witness box. I have them practice. We go through the whole rigmarole. And the clerk's office has always been exceptionally accommodating of me because obviously sometimes that happens on a really short timeline. Schedules are bad. Some of the deputies have stayed late to keep it open so I can show kids the courtroom. So our clerks and our sheriff's office has been like also dynamite on that sort of stuff. So if you think it would be helpful for your kid to come on a day when the courtroom is just quiet and not in session and get that done, like you should feel free to call our office. call Sam, call Carrie, our paralegal. Like we can help set that up and make that happen. Tell the social worker to tell us. Like all of those are good avenues to get to us. And all of your CASA supervisors know where to find me too. So they all can get in touch with us. But that is something that we have done in the past, and I think it has helped a lot in some of these cases where kids especially have to testify against their parents. I don't want them coming into that courtroom for the first time to do that day of. And we've also used, if you think it's appropriate in your case, the victim witness, our victim witness, the criminal victim witness unit has a therapy dog. And I used that for the first time on one of my cases. I believe I'm the first person to ever bring the dog to court. But we did, they can't do that in criminal cases in the actual room where they're testifying because there's appealable issues there on the child, you know, uh, getting an advantage from the dog or something. But in our case, the parent waived that right, and we were able to have the dog sit with the child while they testified, and that was hugely helpful. And if victim witness does not have another case or another kid who needs that dog, they have also been like really lovely with us about having their therapy dog come. And especially if you got a kid who's going to have to wait in a waiting room for a long time, might be super stressed out, that sort of thing. We've tried it once. It worked really well. If you've got an animal lover, like we might try it again if you could let us know, that sort of stuff. That kid just happened to let us know that she loved dogs, so it was easy for me to then make that connection. But I don't know every kid in our system who loves dogs. So if your kid loves dogs, like you let us know, and let's see if maybe victim witness would continue to be kind to us again about that. And it's a really cute golden retriever. So anyway, the protocol, the vision is to provide children in child welfare cases resilience-driven, trauma-informed, and age-appropriate opportunities to participate in court proceedings. Our goals were to create clear guidelines about what expectations for children's involvement would be, to provide safe and meaningful participation by children, to comply with the statutes that require the court to consult with the child, to ensure that participation in TPRs complies with Virginia Code, and to ensure the paramount focus of the hearing is the best interest of the child. So in our protocol, when should children be in court? There shall be a presumption of presence in court for children's ages 12 to 17 from disposition until permanency is established. So we're talking about that final hearing on the CPS side until permanency. We are not at this point advocating that kids should come to the ex parte hearing, that they should come to the 5-day hearing, or they should come to the adjudication. In my mind, the only way they should be at the adjudication is if they're a witness that has to testify, and then I'm bringing them in to testify only for their testimony and getting them back out, because those adjudications, as you all know, can get pretty ugly. I don't think the volunteers are usually there for that, but the supervisors are, and they know that those hearings are contested as if you're in like a full criminal trial sometimes. And so that is not a great thing for kids to see. I've seen parents go on the stand, call their kids a liar during those hearings, say they're full of it, they made it up, uncle's not touching them, yada, yada. And that would be very damaging for a child. So at this point, we are not advocating that participation at adjudication. We may get to a place where we feel like we have a way to handle that is better. But right now, we don't feel good about that. So we're only advocating disposition until permanency at this time. We may learn some lessons along the way that tell us how to handle that adjudication piece, but there was real consensus between DSS lawyers, GALs, judge, that those adjudications can sometimes get extremely ugly and nasty. And that's just really not in the best interest for kids to see that. There shall be a presumption of presence in court for foster care alumni who are participating in the Fostering Futures program. This was already true, but we're just putting it in writing. Children of all ages are permitted to participate. Again, that's that presence versus participate in court via letters to the presiding judge, youth report, drawings, and the like. In Roanoke, they advocated that this could happen with foster parents. We talked about it, and we don't really feel like that's appropriate because a lot of times the foster parents' interest might be adverse to the parents. And so I do feel like this is a place where this could be more of this could and should be more of a CASA thing than a foster parent thing. But like I said, if you've got a kid who wants to write a letter, likes to do drawings, wants to make a silly video, wants to show the court a video of their dance recital. Great. Those are all good. Like if you guys got that stuff for us, let's use it. Let's be thoughtful and creative about how we participate. Um, there's no presumption at this time for children under 12 years of age to be physically present in court, but no request by a child to attend court should be denied unless one of the reasons for excusing a child applies. When should a child be excused from court? When the child, after being fully advised in an age-appropriate manner, chooses not to participate and has expressed that to the social worker and or the guardian ad litem. When the child is in an acute hospital setting. When the child is in a residential facility and the child's clinician does not support participation. When the judge reasonably believes the court appearance may likely cause trauma to the child. And look, some days that might just be based on how mom or dad is behaving in court, right? So that might be a call the judge has to make day of on a case-by-case basis. Um, when the child's guardian ad litem, after one-on-one meeting with the child, reasonably believes the court appearance may likely cause trauma to the child, and when the child cannot meaningfully engage in or understand the proceeding due to a development or other disability as documented by the social worker or guardian ad litem. And so obviously this gives kids a lot of wiggle room because we know some of our kids don't want to go to court, and that's okay. They're probably going to fall under one of these exceptions, and then we refocus ourselves to, okay, what does participation look like for this kid if it's not going to be presence, right? And so that's what we're trying to advocate is first presence, and if we can't get to presence, let's talk about what participation should be, and let's be creative about participation. How may a child participate in person? This is the obvious one, right? They're going to be in court. They're going to talk. The court has full discretion to exclude the child from the courtroom if necessary to protect the physical safety or emotional well-being of the child. And so this is what we were talking about doing kiddo there for part of the hearing. And judge can say, ugh, I know this is going to be ugly when we talk about these substance use results. Let's leave kiddo out and they can come in at the end and tell me what's going on. I'm going to talk to them for 5 minutes without the parents, right? So we're trying to be thoughtful about what that looks like. Parents have rights. They may object to some of this. We can prep kids to say, look, we're going to try and ask for this. If your mom or dad objects, what do you want to do? Do you want to just not go at all then, which is okay? Or do you want to then decide to face them? Or do you want to decide that on the day of, which is okay, right? And so there's a lot of different ways to do this, but we're looking for creative ways to do in person, basically. We are permitting in-camera meetings with the court outside the presence of parents and guardians. Any request for in-camera shall be made orally at the start of the hearing or in writing in advance of the hearing. The decision regarding court attendance needs to be made at least 1 week before the hearing so the department has adequate time to secure transportation for the child. Transportation is a huge thing for the department. It's a lot of work. It's a lot of time. Some of our kids are placed so far away due to the scarcity of foster homes, as you all know. And so we really do need an answer a week before. And so the social worker will work on that. But also if you guys have good ideas for transportation or support people who can be involved in that, I think the social workers would be welcoming of that input as well. Virtual participation. The child should be allowed to attend virtually if the child resides more than an hour's drive from court. Child should be allowed to attend virtually if they express the wish to participate in the hearing after the time by which the department is able to secure transportation. And the child should be allowed to attend virtually if in a therapeutic or residential placement. So that's a bit of a change for us. We hadn't been doing a ton of virtual from residential facilities. I think I've only done it once or twice, but both times I did it, it went well. And so we're going to try to incorporate more of that from residential, especially because I feel like most of you probably know this, the kids in residential feel extremely isolated. And this is a good way to provide that sense of connection, but we're also not taking them out of a locked facility, like, right? So that's where we are. Other types of participation, some ideas we had were a letter from the child, artwork, get to know you form filled out by the child, audio or video recordings made by the child. So those are some ideas we had, but like I said, we welcome all ideas. And then we made a checklist as well. And the checklist, I think you'll see, is assign responsibility for each of these tasks as agreed to by DSS, GAL, CASA, CAF, the foster parents, or someone else. And these are all things that we decided and agreed on as that best practice committee where everybody's got a seat at the table. So you'll see I've broken it down into these are the tasks that need to be done prior to the court hearing. Who is the person responsible? And the date completed. And so our hope is that folks will like and use this checklist and fill it out on these cases. Obviously, the social worker and the GAL are probably not going to be filling out the same piece of paper, and that's okay. But keeping this checklist and marking it for yourselves, I hope will be a helpful tool. Certainly, social workers don't need more paperwork in their life, but it should be a good guide for them, and for hopefully for you all as well. And importantly, I think it puts a little bit more on the GALs to mark that they've done some of this stuff, right? And that they've done it with enough time in advance of the hearing. Um, these are some of the things that, like, for these tasks, determine if they want to attend court, explain the importance of their input, address their concerns about attending court, consult with the therapist to determine if there are any concerns. So some of these are things that, need to get done, and also like ideas to make sure you all, the GAL, and the social workers know these are the topics you should be covering, right? Preparing the youth for the court hearing is the second kind of division of this. Discuss who will be present, explain wait times, bringing materials, right? That's something I talk about with every witness ever. I had one bring knitting once as their material, and the court was like, yeah, no, you can't bring those needles in here. So now I tell people, don't bring your knitting, but maybe bring some books to read. Coordinate with a supportive person to make sure they're able to attend the hearing with the youth. A lot of times that's going to be the foster parents, but it's not always the foster parents. So, if there's somebody else in the kid's life, like I said, like an older adult sibling or something, see if that person can join us at court too. Review the plan, decide whether the youth should participate, discuss if the child wants to speak directly to the judge in the courtroom or in chambers or not at all. I know plenty of kids who want to come and hear what's going on, and they absolutely would like melt into and become one with their seat if the judge asked them a question that they had to answer on the spot in front of everybody, right? So anyway, those are the things that we want to suss out before, and then we also want your all's input to the social workers so that it ultimately gets to the attorneys and the GALs so we can tell the judge, hey, she does not want to answer any questions, but she does want to be here. That sort of thing. And so we've got a during the hearing checklist, and we have come up with a timeout system. So the child can just kind of raise their hand and say, like, yes, the judge gets a heads up that the child is attending, as long as we, the attorneys, get a heads up that the child is attending. We put that on the docket sheet for them. We mark it that day. I just saw one of the questions. If there are other questions, I haven't seen them all. But the timeout system, we did pick CASA as the support person to accompany kids on their timeouts if they want one, because of course all the attorneys have to stay. The social worker has to stay in the hearing because they're parties to the hearing, and so you all have the unique ability to be a little bit more optional, and so CASA was picked as the kind of timeout folks if kiddo wants to leave. Like we talked about, if the kid wants to be excused for certain portions of the hearing, that's up to the GAL to let the court know and explain why to the court. Like I said, I don't expect any pushback from our judges on that. I think they'll be totally fine with whatever the kid wants. Debriefing after the hearing, as you can tell, these are kind of chronological in the order of what you need to do before, during, after. But spend time with the youth after the hearing. The piece we talked about reviewing court orders, explaining what's going to happen on the timeline between this hearing and next hearing. Contacting the caregiver, which could be the guardian, which could be family, which could be foster parents, just to let them know what happened at the hearing, how it impacted the youth, and then also, like, ultimately it's probably going to be CAF or the foster parents getting that kid to like therapy if court was very upsetting to them or that sort of thing, helping them schedule another appointment. The social worker will handle contacting the therapist to provide any information from the hearing that might be relevant to treatment. Allow the youth to ask questions. That's all. Everybody should welcome questions from their kids, and so that's an important one. And CASAs have been elected to provide a written summary of the hearing if the youth is able to read, regardless of whether the youth attended the hearing, since you all already work on that in your reports. So that's the protocol, that's the checklist. Does anybody have any questions? I've seen a couple of them come in, but I haven't certainly have not seen all of them. So
Yeah.
I'll turn to Leah for that.
Lauren, we had a question about the FPM notes, if the kids also get the FPM notes. I imagine if the youth goes to the FPM meeting, they probably would get
Yeah.
a copy. But if they're not there, I doubt it. But I don't know if you.
That would be my assumption as well. I don't know that for sure, but I know that the policy is that all participants get a copy of the notes. So the question is, did the kid come to the FPM or not? If they don't come, I don't think they get a copy, but they're certainly welcome to request a copy. I can't imagine that they wouldn't give them a copy if they wanted them. FPMs are super important, but I also understand that sometimes they can be overwhelming for kids, and even kids who maybe want to be involved and attend court do not want to go to all of their FPMs. And so, you know, if you think there's really valuable stuff in the FPM notes, like I think that that's a place to like you all should feel for the over 12s to talk to the social worker to say, hey, I think they should get a copy of this month's FPM or whatever.
And there's questions about our CASA report, and in the code, we're actually not allowed to give those out. We can only share them with certain people, which is getting them to the clerks who then give them to the attorneys to talk about with their clients. And so we don't give them out to the kids because it's in the code. Good question. And I don't know if anybody else has questions they want to raise.
I have a quick question. Lauren, what's your sense of how flexible are the courts going to be as far as using WebEx or letting kids attend virtually if they don't live more than like an hour away or they're not in a residential setting? Is there wiggle room there,
I
or
think
what's your
so.
sense?
Yeah, I think so. Like if it's like, oh, they want to come to the hearing, but they have practice after school, so they can't be sure they're going to be back on time, like that seems like totally appropriate to me. I think the judge probably wants to see people in person, so we may just have to have some kind of understanding of that. Or like too, Steve, if it's like, oh, they need like a lot of timeouts and the ability to like turn the screen off and walk away. Like, I think there's a lot of different scenarios I could imagine that would be a perfectly reasonable explanation for the WebEx versus in person for close people. We probably just want to talk about it and come up with a plan about how, we make sure the GAL knows that it get explained to the judge. But I can't see Judge Pather having a problem with, my sense is no. I haven't asked, but my sense is no. I can't see her having a problem with that.
And I just want to say, so we do have another question that came in. It is at time. If people need to hop off, that's okay. I don't know if you have time to answer a few more questions, Lauren.
No, I can do a couple more. Yeah.
Hal said, if the child writes a letter to the judge, does anyone else see that letter?
Yeah, so good question. I think from an evidentiary standpoint, everybody has to be able to see that letter. It doesn't mean the judge is going to admit it as evidence. It doesn't even mean that I would argue, if I got an objection, it's not being admitted for the truth of the matter. It's just being admitted for what it is, which is this is how the child feels. It doesn't make it true. I don't know where I'd get on that. That would be my response. It is hearsay. And so I think if you're going to admit hearsay, everybody's going to get a copy of it. And so I do think if you've got a kid who's like very afraid of like talking in front of their parents or saying specific things in front of their parents, that might be a time where we kind of talk through, well, is it better for them to come and do an in camera and something like that versus the letter that their parents might read? I don't know. So, I think that that's a really good question and part of the area that we're trying to feel out. I don't have a great answer for all of these things because we're like I said, we're starting from zero. We're trying something new, but that's a really good question. And I think that if you've got a case like that where you've got some concerns, let's get with the GAL, let's get with the social worker, let's make a plan, and please, CASA, bring that to our attention and let's work through what that should look like. I think a lot of these letters are going to be like, I'm in school, I don't like my science teacher, but I like my English teacher, like blah, 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 like such that parents won't object to them. I think a lot of them are going to be kind of bland, but if you've got one that you think they're ready to just unload or something, let's talk about how we make that have evidentiary value.
Great question. Any other questions? And if you have more that you think of afterwards, feel free to reach out. Like I said, you can reach out to me, you can reach out to your supervisor, and we'll try and find the answer for you.
I have a question. When a child says that they want to write a letter, in the past, this is a while ago with another case, um, the child gave the letter to the social worker who decided that it wasn't going anywhere.
Mm,
But now, Lauren, you just said that if a child writes a letter to the judge, everyone
mhm.
will. So maybe that's changed. I don't know. But if a child writes a letter, does she give it to her social worker?
So I mean, I've seen it done a lot of different ways. I've seen it handed to the social worker who then handed it to the judge. I think the better way is through it for it to come through the GAL personally. I know some kids have a strong bond with their social worker, but I think it's better suited to come through the GAL. I've also seen kids just straight up write a letter to put the court's address on it, put it in the mail, not tell anybody they did it, and it shows up at court, and the judge said, "I got a letter," which is okay. That's their First Amendment rights to write to their government, right? Like that's fine. There's nothing wrong with that way either. But in my mind, I think the best route from an evidence perspective would be to route it through the GAL.
Good. Yeah, thanks.
I appreciate all of the questions and everybody just again being here today to learn about something we're trying out. And I think it's great. A lot of thought went into this to try and support all the different pieces and all the before, during, and after. So, and appreciate all the CASA's work to help with this and get it going.
Yeah, and I think we're also definitely looking for feedback. So as you all kind of see this stuff in practice, like we very much would be interested in their input. If you can send that up your ranks to your CASA supervisors so that it can get back to the committee. Like I said, we're trying something new. We want to make it work, and we want to learn what to do better also as we move forward. Like this is version 1 of the protocol. I don't think it will be the last. So please give us your input as you see it in practice too.
Yeah. And please work really closely with your supervisor. They'll help you with the pieces and kind of talk through what's best for that particular child. Every kid's different, every case is different. And so definitely work with your supervisor on all of these things. And just thanks again. Thank you, Lauren. We appreciate your time and lots of information for people to digest and work on as we go forward.
Well, thanks for listening to me talk for an hour, guys.
Yeah.
Nice to see everybody.
Lauren,
Yeah.
one more question.
Oh,
Will we
yes.
get a copy of your notes that you showed us during your talk?
Yeah,
Perfect.
I can send all the materials over to Leah if you don't already have them, Leah, from the conference.
And I sent 3 documents through the supervisor team, but I can't remember now if all of these were on there. I know the protocol was, so we'll make sure you get all the things you need.
That would be really helpful. Thanks.
Yeah. And hope you all have a good rest of your day. Thank you.
Bye, everybody. Thank
So
you.
much.
Bye.
Thank you.